Three major changes were announced in the UK on 9th of April 2025. Change 1. The UK Home Office has increased fees for sponsor licenses and certificates of sponsorship (COS) among other fee hikes. Change number 2. Care providers in England must first attempt to hire within the UK before recruiting overseas for care workers SOC code 6135 or senior care workers SOC code 6136. Change number 3. Salaries for care workers have increased from £23,200 per annum to £25,000 per annum. I posted a detailed video last week on both my Instagram and YouTube channels, and I noticed plenty of questions in the comment sections. Therefore, I decided to do a Q&A with an expert, Amil from Mac25 immigration firm, to address some of the unanswered questions. So, if this topic is relevant to you, stay tuned until the end. But before we do a deep dive, a quick introduction about myself. My name is Sarika, and I have been living in the UK for the past 15 years. I'm currently working as a lead business analyst at one of the largest tour operators in Europe. Without any further delay, let's invite Amil and get started with today's topic. Hi Amil, welcome once again to Your Knowledge Buddy, and if you don't mind, can you please introduce once again to my audience, please?
Hi Sarika, hi everyone. So my name is Mohammad Amil, and thank you so much for loving me, for calling me, messaging me, and liking our videos. So I'm very grateful to you guys. So I'm an immigration lawyer based out of Canary Wharf. We have our own immigration law firm Mac25, and we assist businesses and individuals in all kinds of UK immigration laws.
Okay, and you're ex-international student as well, Amil.
I am an ex-international student, and I'm proud of it.
And you should not forget to say that in your introduction. Okay, so Amil, thanks for coming. Today's video is all about Q&A because last week I have posted a video about the recent changes which were announced for 9th of April. And I still have many questions there which I didn't get a chance to respond to, and also from Instagram. So what I have done, I've taken all those questions from all my social handle and I have put down here for you. And I promise it's not going to be a difficult question. Okay.
Is it like a rapid fire, Sarika?
Yeah, kind of.
Am I getting a hamper?
Rajma chawal at the end.
Okay, fine. Rajma chawal, best. Yeah.
Okay, so I'm going to throw my first question to you. Okay, so there's a confusion about the salary threshold which is increased for, it says carer and senior carer. So the confusion is it only for this two job code or is it for other job codes as well?
No, it's specifically for health and visa categories from 9th of April 2025, specifically for these visa categories which comes under health and care. So obviously skilled worker is like an umbrella and health and care comes under the discounted rates. So it's increasing from 23,200 to 25,000 pounds only for health and care categories.
And can you remind us what is the job code for carer and senior carer?
So it's 6135 and 6136.
Okay.
But I also want to make sure that the reason of this increase, because the Home Office wants to make sure that the salaries of healthcare workers are aligned with the increasing national minimum wage in the UK as well.
Yeah, correct.
That is very important to understand why it's happening.
Okay, so does it mean that there are other jobs as well, say on immigration salary list where the salary is not too high? Is there any impact on other job codes as well?
A lot of impact has already happened in April 2024, so there's nothing on that.
Okay. I mean, one of the questions which I got again from another person called Surya Prakash, he's saying he applied for his visa before 9th of April. His employer applied a COS before for carer or senior carer. He's saying what changes will impact him before 9th of April. So I believe nothing impacts him because he's part of the old rule. Old rule means all the old visa fees or the other changes.
Exactly. So if you have been part of that lucky group, I would say, before 9th of April, if your COS was assigned before 9th of April and you submitted your visa application, then you obviously fit the bill of 23,200 and nothing would impact, irrespective of whenever your decision comes in.
Okay. So I have now, sorry, but this is a difficult question. Okay. So this is about, Jaya is asking, what are the recent changes around self-sponsorship and sponsoring investors?
Hi Jaya, thank you for asking such an important question. And it's like a maze, to be honest, when it comes to self-sponsorship. We have made a lot of videos together.
Correct.
We have made our own reels and things like that.
Correct.
But as per the new rules, what the Home Office actually want to do, they want to close this loophole which allows an individual to start their own company and obviously get a sponsorship on that company. We have done a lot of cases like that. We are still doing it, but obviously there's a way to do it as well. But now what the Home Office really wants to do, let's say if I'm the director of a company and I'm investing X amount of money, so that X amount of money will be averaged over a period of whatever years of COS I have applied, and that would be deducted from your gross salary. So that you need to understand. Let's say your salary is 40,000 pounds and you invested, let's say 20,000 pounds and your COS is for 2 years. So your average becomes 10,000 pounds. I don't know whether I'm good in maths. So the 10,000 pounds would be deducted from your 40,000 pound salary, and that's what the Home Office would consider.
Correct.
So that you need to understand that where you exactly fit the bill. Let's say if you're a new entrant, the minimum salary criteria is 30,960 as per the going rate
Correct.
of the SOC code, and now your salary has been calculated from 40,000 to 30,000 pounds. So there is the gap of 960 pounds which will refuse your visa application.
So is it already there on the white paper, or this rule will be published later?
So it's there in the guidance, the updated guidance, and I think white paper would have few measures which we'll get to know in the future, because what is yet uncertain that whether the authorizing officer also counts in the investment or not, or here we are just talking about the specific individual who are investing the money in the business. So there's a lot of question that needs to be answered, but this is what we have understood from the guidance till now.
Okay, so are you still processing then any of the application for self-sponsorship?
Yes, we are, but at the end of the day, we have reduced to a greater extent, because what we need to understand that you just cannot come and start a random company just for the sake of sponsoring yourself. Because now, if you're coming to Mac 25, and this is for all the audience watching coming to us, if you're coming to us and saying that, Amil, I want to start this company and I don't have any experience, I'll just sponsor myself. This is not how things work. Let's say if you're a nutritionist, or maybe you're a dietitian, or maybe you are an IT consultant, you should only start a company for which you have got a skill, and then get an authorizing officer who can actually work for your business rather than just having a name sitting on the company's house and being and doing nothing. So those are the things we are also processing. We are doing our own due diligence as well, and now we can only process self-sponsorship visa where we are satisfied that this is not going to be a sham. So that is really very important.
Okay, what happens to those applications which are applied or submitted but there is no decision yet, and based on this guidance which is published, will it have an impact on the applications which are already submitted?
Let's say if you have already applied the application before 9th of March, it's not going to impact you. But whatever applications are being done, let's say the license is in the process, the COS is in the process, they're all going to get impacted.
Okay, so 9th of March or 9th of April?
9th of April.
Okay, good.
Yeah, 9th of April, guys.
Okay, good. Alrighty. So any kind of suggestion you have for people who are still interested to apply for self-sponsorship?
The most important thing I'll say, if you really want to get into this self-sponsorship, understand this is a skilled worker visa where you are allowed to be a shareholder and the director of the company, and this is not any other visa category. It is a skilled worker. If you really fit the bill, as I always say in all my videos with Sarika, you should be only eligible if you have got that kind of skills, knowledge, mindset, and genuine intentions to be in this country.
Okay, thanks Amil. Moving to the next question, and this question is from Mr. Vishnu. Vishnu is saying, as we know in the UK, there are small startup companies who got a license now, and they don't want to absorb all the costs because they're not making a lot of profit. So what they tend to do is, when they hire people, they say, okay, we are hiring you or sponsoring you, but we are not going to bear your cost, visa cost, processing, COS. So they tend to move all that cost to them. So is it genuinely allowed, and what are the new announcement or guidelines from the government around it?
So let's say we are talking about the present now. So the Home Office has made it very clear that they are prohibiting the sponsor for recouping the cost of sponsor license fees, certificate of sponsorship, or immigration skills charge that had to be paid by the company itself. Because at the end of the day, the Home Office wants to make sure that there is nothing else going on behind the scene if the candidate is paying these fees themselves. But one thing I want to make clear, I don't know whether this is part of your question or not, the immigration health surcharge and the visa application fee is completely dependent whether the company wants to pay it or whether the students wants to pay it, or maybe the applicant.
Okay.
Only the fees associated with the sponsor license, certificate of sponsorship, immigration skills charge, that needs to be paid by
the employers.
Yeah.
Okay. You know what, Amil, what I've seen, because these people, migrants who need sponsorship, they tend to just give that money and they don't want to go and complain to the Home Office that the employer is asking for it, because they are small startup companies. They know they are not making huge money, and they also want to stay legally in the UK, and they think it's easier. They are just paying it because it's not a huge money and all.
Yeah,
but
that's true.
And they don't go and complain about it. So I really don't know what they should be doing.
I think the whole sense behind this, what I understand from my own understanding, whatever time I have been in this industry, that Home Office wants to understand that sponsor license is linked with the expansion of your business. So let's say if I'm a restaurant, I I make delicious Indian food, so I need to hire that kind of specific Indian authentic chef. And for that, it is my responsibility as a company to bear that cost. Why should that Indian chef to work for me, to maybe show his skills, or maybe to, prosper my restaurant, pay from his own pocket?
Correct.
So this could be the mindset behind this, I believe.
I think high competition, market is saturated. Many people are here who need sponsorship and many more things.
True.
Okay, thanks, Amil. Now moving to the next question, and the next question is from Aisha. Aisha is saying, if someone is on a care worker visa and was made redundant, what kind of help they can avail from the UK government now?
Yeah, Aisha, thank you for this latest update. So that's a very good thing. And I think there's two parts to this answer, because from obviously as per the new rules from 9th of April, a lot of my clients have started calling me from the care sector that they're not able to hire new people, let's say from outside of the UK, or maybe people from different visa categories within the UK itself, because now they need to contact the regional partnerships. The regional partnership obviously will give the contact details in the video, that they need to go to the regional partnership. They already have a pool of care workers who are already here in the UK on a skilled worker care visa, maybe who are not getting enough jobs, not getting enough hours, and the employment has been redundant. So what they need to do, they need to speak to the regional partnership, give out their name, and then obviously the companies who's searching for them will definitely interview them and identify them and give them a new sponsorship.
Okay, so if I'm in East London, how do I know whom to reach out? How do I know who are those regional partners?
So there are a list of companies which we are going to give it, maybe I'll post it, or maybe we'll put it in the link. Each regional partnership, they can contact them and they can give the numbers and the details and what's their current situation in the UK. But please guys, make sure you're not illegal, or maybe you do not have any other visa category. It's only for specific health and care workers.
Okay, so those links and demos I have provided in my last video. In fact, I'm going to pin it in this video as well. If you cannot find it, just comment link and I'm going to comment it back to you guys with the proper link where you can see the email address of your regional partners as well. I also read, by the way, on the same portal of the government, it's not only about the job, they're also providing other support because they're mentally disturbed, carers, senior carers, because of a lot of other things which has happened. They had been mistreated, for example. So they're also providing some mental support as well. In fact, I read and heard about some financial support as well there, which is being provided. So I'm going to encourage people to leverage this opportunity if you really need help, irrespective of what's happening in care industry or not. Just try to reach out to your regional partners to see how you can benefit from the help which is provided by the government. This is a government initiative. In fact, there are now £60 million which is set aside just for care industry to help carers and senior carers, which is commendable.
That's a bold move.
In fact, yes, which is good news for care industry,
Exactly.
Yeah. All right, now moving to the next question. Next question is from Joy, and he's asking what new compliance measures are being introduced for right to work checks, especially for low skilled workers or roles like people who are at 0-hour workers or people who are working, say, at a fast food restaurant. Are you aware of any checks which being done?
They have introduced a term which is gig economy, which I don't use often because people normally don't understand that. But gig economy is something like if you're working in a low skilled role, or maybe if you're working on a 0-hour contract, or maybe you're working, let's say, once a month or twice a month, and you don't have a permanent employment, you're working in construction industry. Now it is very important for the employers who are hiring such people on 0-hour contracts, they need to do their right to work check as well within the country. Because what is happening, let's say if I'll just take the Indian restaurant example, okay? If I'm hiring some chef for like once a week on a 0-hour contract, maybe just for weekends, that specific chef makes the best biryani. So that specific chef is only coming on a weekend. I'm not concerned, he's coming on Saturday, cooking the biryani, going back. Now it is my responsibility to make sure that whether that specific chef had got right to work in the UK or not. So that has become really very important, and it belongs to the construction industry as well, where you have got workers like bricklayers, masons, roofers and things like that. So you need to have right to work check and need to have file for each of those. Let's say if Home Office wants to come for an inspection, you're well prepared. Otherwise, get ready for £60,000.
60,000 pounds.
Yeah.
Wow.
Per individual.
Per individual. Amazing. Okay, thanks, Amil. Moving to the next question. Now, I have two persons asking this question. One is Samatha and another is Anil. This is regarding the supplementary work.
Okay.
As we know that government allowed now people to work on supplementary jobs as well.
That's true.
20 hours per week is allowed. What they have said, and kind of same question they have said, some of the employers, especially the startup companies, like fast food restaurants and others, they generally tell, okay, these jobs are in the eligible skilled jobs which are listed. They assign you or they hire you for that, but actually they make you do something which is not related to what it was advertised for. So what is your piece of advice for those people, whether people first of all they should be doing it, and of course I know employers shouldn't be doing it, but what those people do who think, okay, because it was advertised under eligible job code which is listed under the supplementary job, should they go ahead and do it?
See, at the end of the day, what I understand, whether you are a sponsor, whether you are a normal company, it's a big responsibility for you to hire anyone who's on a skilled worker visa. Even if you're not a sponsor, you need to make sure you're not hiring anyone illegally. So a lot of companies think, oh, we are not a sponsor, we don't have any obligation. No, you do have an obligation now. As we just spoke about the low skilled roles and the 0-hour contracts, even if you hire somebody on a supplementary income, you need to make sure you exactly give them the same role. And it is not just the responsibility of the employers, Sarika, it's the responsibility of you as well. If you're working as a student, you're working as a skilled worker on a supplementary employment, you need to make sure that code needs to be on the appendix code of table 2.4. I'm not sure exactly about the tables, but people are very smart. They know what table I'm talking about, which is only for skilled workers. So at the end of the day, if suddenly you realize, oh, I was hired as a warehouse manager, but I'm doing just a driving job, okay, then you need to go out of that job. Because if Home Office founds that out, then you are out of this country.
Okay, oh dear. All right. I hope you guys are making a note of it.
Yes.
Okay, so moving to the next question, and this question is from Omar Mia. Omar Mia is saying, have you heard or have you seen any news related to the graduate visa holders? I mean, have you read anything on the public domain? What is your take on it?
Being into immigration consultant, we watch a lot of videos, we read a lot of articles, we are into so many things, we watch Sarika's videos. But at the end of the day, when I have read an article which says that, I don't know whether it's official or not, we are yet to see when the white paper comes, whether the new guidance gets updated about the graduate route. But as the government is looking to reduce the net migration, and it's associated with graduate route as well, which got saved last year, but this year I have read that obviously it would be linked to the kind of job they are getting in terms of the salary. Let's say if they are getting salary of about £30,000, then only they are eligible to get a graduate route.
Correct.
So I think it's a lot of them linked to that, but we have to wait and watch, because I tell to all the students who's commenting on the videos or maybe DMing on LinkedIn and Instagram that let's wait, let's be calm, let's understand what is going to happen, and then think what's the next step, rather than just doing a stampede and being chaotic. So we need to understand, let's wait for the white paper, let's wait for the updated guidance on graduate route, and then decide what needs to be done.
Yeah, so do not panic now, because this is still not published by the government. Yes, there are some articles which is there in the public domain. We have read it, you have read it, but again, it's not a rule, it's not a law at the moment, and when it will be, we will come and talk about it in detail. So do not panic now. Okay, thank you, Amil. So just have one or two more questions now. Next question is from Rahul. So Rahul is asking about visa extension fees. So we already know that the fees were increased now on 9th of April, whether it's CUS, license fees, sponsor fees, and other bits, and the visas as well. So if someone is extending their visa, say we're extending their skilled visa or some other visa categories, is the new fees also for them as well?
Yeah, exactly. So if you're extending your visa after 9th of April or anything, you're applying for a new one, you do get eligible for the new one.
Okay. Was there any visa category for which the fees was not increased?
I think only the sponsor license.
Okay.
As far as I remember, only the sponsor license. There were few visas as well. I don't
Student
remember.
visa?
Yeah, I don't think so. Student visa has increased. We need to have a look at it.
Okay.
But
yeah,
100% I am sure as a business immigration lawyer, sponsor license has not been increased.
Okay. Thanks, Amil. Just last question before I let you go. And again, this is from Meera. Meera is asking, again, we have talked about various changes, and discussed in detail, but we did not talk about spouse visa. And hence she's asking, is there any new update around it, especially around the financial requirements which people are worried about?
So the current financial requirement as we stand today in in April 2025, we do not have any update. So the current requirement is £29,000, and obviously when the Conservative were part of this new requirements, they aim to increase it phase by phase, and by this time it should have been increased to 38,700. But as soon as the Labour government came into power, they put it on hold on it, and because they wanted to see either the British people are getting exploited by it, and there are a lot of heartbreaks, a lot of families are not getting reunited, and things are happening. So in June 2025, we'll get an update on that as well, that what is the actual financial requirement going to be.
Correct. So as of today, there's no update as such.
Not in April 2025.
Okay, good. Thank you, Amil. So guys, I have tried my best to take questions both from my Instagram comments and also my YouTube from my last video. Of course, some of the questions were irrelevant, which I did not discuss with Amil, but most obvious questions and the questions which definitely required some discussion and expert advice, which I have already discussed with Amil. But if you still feel like if your question was not picked or is not answered, feel free to put it in the comment section. I'll make sure I'll get Amil to talk about it maybe in the future, or I'll make sure we get a response to you guys. Anything you want to say before we wrap today's video, Amil?
Yeah, I think we always talk about that, and I've been in this country for about 9 to 10 years now, and what I feel, every year something new might come. It might be in your favor, it might not be in your favor. But rather than reacting to videos who are not regulated advisors, solicitors or barristers, panicking yourself does not make any sense.
Correct.
So let's be calm, let's see what we can do, how we can help you legally and ethically to be in the UK, and then obviously we can make a decision what could happen in the future, rather than thinking what's gonna happen in June, what's gonna happen right now.
Yeah.
Be relaxed, have faith.
And in case if you guys got any questions or queries, you can reach out to us at ykb@mac25.co.uk, where Amil and the team will be helping you guys. And very soon, Amil is going to start his few minutes catch-up call with you guys.
The consultation is going to get right really very soon.
Yeah, and you guys can jump on a call and discuss. If you have any burning question, you can ask Amil. Thank you, Amil. Thanks for coming and sharing your knowledge. Thank you
so much. Yes. Thank you.
Thank you.